Other form is answer Munina Aquaba at the Ghanatube. So the form that Kai Akwatia MP no Supreme Court. The special ruling about concerning Akwatia MP na in this case court in Semna chese ye senior basa court no high court na the for Akwatia MP no sian or a free man court need the special ruling about for man ko na yen court ruling no Supreme Court yemba see Ghanatube so
So, by decision of 4-1 today, the Supreme Court has agreed with Counsel Nimako and said that the contempt application, its hearing, and the subsequent conviction on it all has been quashed. So, as we speak right now, Honorable Ernest Yakumi remains the MP, the elected and valid MP of the good people of Akwatia. And on the second issue was the matter of the petition itself. On that, the court said that the judge, the learned trial high court judge in Koforidua, can no longer sit on that matter because his conduct has shown that he should not be allowed to continue sitting on the matter. So even though we may go back to Koforidua, but he won't be the judge to sit on the substantive matter.
Thank you.
But our main contention at the Supreme Court was that the contempt, its hearing, it's the conviction subsequent to the contempt, the sentencing. If you remember, there were even attempts to have Ernest Kumi arrested, Honorable MP. All has been quashed by the Supreme Court. So as we speak right now, Honorable Ernest Yakumi remains the MP of the good people of Akwatia.
Thank you. To conclude that the injunction itself also has been quashed.
The conviction, the bench warrant. If you would remember, there was a bench warrant issued by the High Court Koforidua. It has been quashed as well.
No, I'm referring to the injunction that was granted on June 6th, ahead of the June 7th.
Yes, it was stayed. The bench warrant was stayed by the Supreme Court to abide the ruling today. So as at now, per the ruling of the Supreme Court today, no bench warrant exists. So everything has been quashed. He's a free man and he will continue his good work as an MP.
But the question is, you remember that the court issued an injunction against his swearing in as an MP.
Everything has been quashed. Because all those things were incidental to the conviction for contempt and all that, and the subsequent sentence, bench warrant by the trial court. Everything has been quashed. Ernest Yakumi Honorable is as free as bird.
So now, which of the legs were dismissed?
The debate about the petition pending before the Koforidua High Court, the Supreme Court said we should go back to that, but has prohibited the judge from sitting on that particular case. So yes, for that one, we may go back. I mean, we leave it up to them. We believe that it has no merit, but if they will pursue it, it's their own cup of tea. But let me put it on record. Honorable Ernest Yakumi is as free as a bird, and he remains the elected, sworn-in member of the good people, member of parliament for the good people of Akwatia. Thank you.
Thank you.
No more questions. Please, the full name.
Already.
The full name.
Come already.
Adolfo say just a good news naba. Ama aye the people of Akwatia say Siano Akwatia MP no aye honorable aye Ernest Kumi Sian or a free man or for a caption by Koba Beto Amoman Kaina Yentin Sema Ekoso. Our Supreme Court say everything has been quashed. He is a free man. The Supreme Court has overturned a contempt ruling by the Koforidua High Court against Akwatia MP Ernest Kumi. The Apex Court also barred Justice Emmanuel Senyo Amedahe from sentencing the MP. Chese Justice Biana Chese only ni ending ye ni see the Supreme Court ne yisa justice ne fionom nti see amena okasa no Akwatia MP no oye free man see ade Akwatia fo omenyamu MP see a court case no Supreme Court the final ruling now but judge nankasa no just say Supreme Court the nyina but judgment kese nankasa Supreme Court the nyina but see an Akwatia MP no oye free man see Akwatia fo enyomu MP rofo muma yenko na yensan kotu ya nsem no so emra sisia.
Even though we are yet to get the reasoning behind it, but essentially what they are saying, it's not really a 4-1 majority decision with regards to the first one. You know, the petitioners or the applicant filed a few reliefs, I think about 5 of them, with regards to the substantive matter. The Supreme Court, by unanimous decision, dismissed the 2 reliefs out of the 5. And no, 3 reliefs, and then the 1, 2, 3, and then the 2 which essentially bordered on the contempt and prohibiting the judge from proceeding to hear the matter is what was greeted with a majority decision of 4-1. And so we await the decision, and then the reasoning, and we take it from there. The other matter also had 4 reliefs, 3 substantive reliefs, and then 1 which is the normal thing lawyers do, which is that any further orders. And that also the court dismissed 2, the first 2, and then granted unanimously the 3rd one, which 3rd one also borders on the contempt, which the court, they were asking the court to vacate the ruling on the contempt, which the court actually obliged them and then granted same. And so essentially, per what we heard from the Supreme Court, the petition stands, the matter would go on unabated, but essentially it is the contempt that had that decision of the 4-1 majority decision. So we will go back and then we await the reasoning, and then we will advise our clients on the next way. That notwithstanding, there is still a valid petition, which, because you recall that the thrust of their case was that there was no gazette notification, and that has been the thrust of it. Today the court has dismissed that application. Essentially what the Supreme Court is saying is that there was actually a valid gazette notification, and so there is still a petition, so to speak, a valid one against the Ernest Kumi. And so we will go back and then advise our client, but there is a valid petition against them, we will pursue it.
For clarity, you secured an injunction against Ernest Kumi. He went to Parliament and said he will bear the consequences, and went ahead to take the oath. Did the Supreme Court make a pronouncement on the validity of that particular injunction?
So if you look at, or if you heard the Supreme Court on what their decision is, essentially it appears, per what they told us, that they do not agree with the learned trial judge on the way he handled the contempt matter by a majority decision. And so we do not know the reasons behind it. We await what the Supreme Court, the analysis they made with regards to that, and then we'll take it from there. But essentially, per the decision they have given us, it is clear that they disagreed with what the learned trial judge did, essentially.
Order 4, when a special ruling in the Supreme Court, what you say, a Supreme Court no wabo a judge no wabo na asem no to egu say we oni eye MP ni endi ni ye eye Ernest Kumi no Akwatia MP no ni endi ni ye nti no mo de asem no ko Supreme Court na boss a judge no you say sa judge no ntina sa case no so bi omiti no this time round no eye 4-1 and 4 no call in favor of Akwatia MP. This year no kasa na Akwatia MP no a free man. This year no obesan so go back to the constituency akwa ko bu edumaden ama the good people of Akwatia, and this year Ernest Kumi this year or a free man. And Supreme Court the special ruling na banam speaking in na brew. E wo Ghanatube the former memory if you like no subscribe no share no hit notification bell no so man send e be ya abri bia drop your content a wo nya ne tempa no ahwe no tia me rofo aha ana me di Akwatia MP ni nsem nyina besi e wo Ghanatube makram nyina mdamu nyina se